Welcome everybody. Thank you for coming to our IHL Forum book launch version, or virtual forum. We're very happy to do this event and host a very distinguished group of authors. And I'm very, very happy that we continue with this nice little tradition that we started this year. It's an interesting development where we actually managed to take advantage of the virtual world that we were forced to be in and actually make some advantage which allows us to do this virtual book launch, and actually allows us to do, which I think is the most global event we've done ever, for sure for ALMA. I think, as probably you can relate to, time zones were much of a interesting struggle this time, because our event includes speakers from Australia, from Europe, and from the US, which means good night, good morning, good evening, and good afternoon at the same time to all the people right here on the screen, which is a bit the Truman Show in a way, but we're doing good. Today we are hosting the editors, the authors of the book, Ensuring Respect for International Humanitarian Law. And it's a great privilege to have the speakers, which I will let Carolina introduce in a second. Prior to that, I just want to say a few words about ALMA, which hosts the event. ALMA is the Association for the Promotion of International Humanitarian Law. It's an NGO which is based and registered in Israel, but our activity are, well, officially today, around the world, global activities, even more than ALMA has a lot of activities. We're very active online on social media, but we also have more physical activities like lectures and presentations, and we do cooperate with the local delegation of the International Committee of the Red Cross or the National IHL competition, and we hold conferences and events, all in the purpose of promoting the knowledge, understanding, and discussion of international humanitarian law. So I invite you to follow us on social media, to check our YouTube channel, in which you will find previous presentations like this one, book launches, and we will have we will upload the edited version of this book launch as well. So without talking too much more than that, I'm going to pass the floor to Carolina, who will present the speakers of this book launch event.
Hello, everyone, and thank you all for being here with us today. My name is Carolina Grimberg Golijov, and I'm the forum coordinator, and it has been a pleasure organizing today's event. I'm going to introduce the speakers, and then we will move forward with the presentation of the book. Dr. Eve Massingham is Senior Research Fellow in the Law and the Future of War team at the University of Queensland School of Law. She has worked in the field of international humanitarian law for 10 years with the International Red Cross and Red Crescent movement throughout East and Southern Africa and in Australia. Eve holds a PhD from the University of Queensland and, among other qualifications, an LLM from King's College London, where she attended as Chevening Scholar. She's an Australian qualified lawyer and has published a number of book chapters and articles on IHL and related topics. Eve has also served as an Australian Army Reserve officer. Annabel McConnachie has worked with the IHL team at the Australian Red Cross as a volunteer and staff member since 2003. Primarily involved in dissemination activities, she led the project developing a series of advocacy publications in collaboration with Pacific National Red Cross societies for high-level engagement with parliamentarians. Annabel holds a BA in Law and History from Keele University and a Master's of International Relations from Macquarie University in Sydney, where she lectured and convened units about human rights, international law, and forced migrations for 10 years. Catherine Drummond is an international lawyer specializing in dispute settlement before international courts and tribunals, including the ICJ, European Court of Human Rights, the ICC, and the UN Treaty monitoring bodies. She also teaches in the use of force and international humanitarian law at the University of Cambridge, where she's completing a PhD, and was formerly in practice in international law and arbitration in Paris. Nathalie Weizmann is Senior Legal Officer with the United Nations Office for the Coordination of Humanitarian Affairs, where her work focuses on international humanitarian law as it relates to the protection of civilians and humanitarian activities. Before joining the UN, she was the Senior Director of Counterterrorism and Human Rights Project at Columbia Law School's Human Rights Institute, carrying out research and writing on legal and policy issues relating to US national security, IHL, and international human rights law. Earlier, she was a legal advisor with the International Committee of Red Cross, both at Geneva headquarters and in the field, examining issues ranging from judicial guarantees and procedural safeguards of persons deprived of their liberty to autonomous weapons and responsible arms transfer, and representing the ICRC in arms trade treaty negotiations. She has also worked for various human rights NGOs, the Inter-American Commission on Human Rights, and in private legal practice with Ogilvy Renault with Norton Rose Fulbright in Canada. And now we will move forward with the presentation of the book.
So the order of the speakers is going to be, we're going to start with Annabel, and then we're going to continue with Catherine, then Eve, and we're going to conclude with Nathalie, following which we will have a session of Q&A for the relevant questions that might come up. So Annabel, the floor is yours.
Thank you. And thank you to Ido and Carolina for your introductions, and to all at ALMA for inviting Eve and I, together with Nathalie and Catherine, to speak. And I was going to say speak today, but I've just arrived in tomorrow, or you're in yesterday, I'm not quite sure. What I'd like to do is just provide you with a brief overview of the concept that Eve and I had for the book, Ensuring Respect for International Humanitarian Law, so that you can see what angle we wanted the contributors to take when examining the particular specialist IHL topic that they took. Eve and I met when we worked together for a number of years at the Australian Red Cross in the IHL program there. And so when Eve decided to write her PhD, she generously allowed me to view and comment on her proposal and the initial drafts. Now, Eve wanted to explore weapons law, and she's going to be talking about that later, but through the lens of Article 1, which is common to the 4 Geneva Conventions of 1949, an additional Protocol 1 of 1977, and additional Protocol 3 of 2005. Common Article 1 is also part of customary international law, and it states that the high contracting parties undertake to respect and to ensure respect for the convention or protocol in all circumstances. Now, following the completion of her PhD, Eve and I discussed the idea of articulating what the application of Common Article 1 might look like across a range of different IHL topics. And we came up with a very long list of issues that we thought were really worthwhile, and thankfully found some very willing and very generous experts who were prepared to contribute to the book, and you'll be hearing from some of those today. Common Article 1 requires states to do 2 things: to respect the convention, but also to ensure respect for the convention, and in both instances this must be done in all circumstances. The idea of respect for the conventions is well established and completely uncontroversial, in the sense that it provides that a state party to the convention must guarantee that its own government agencies and people under its authority or within its jurisdiction adhere to the law. There's no real dispute about this idea of acting in good faith with respect to the provisions of an international treaty that you as a state have signed up to. And this is what is referred to, or we have referred to it as, the internal compliance aspect of Common Article 1. It's those activities that are required for the state to respect the law within its own domestic jurisdiction. So whether that's the training of military or the dissemination of law, enacting appropriate national laws and supportive policies and procedures, which are all carried out during times of peace, or whether it's formulating the targeting doctrine which will operate during times of armed conflict. All of these actions fall within respect for IHL, that internal compliance aspect. What we wanted to consider in the book was what ensure respect might mean. Now, largely speaking, this particular phrase has been rather neglected. So the introduction itself takes stock, and I'm not going to sort of go through that in too much detail, but it takes stock of what's been considered over the last 20 years, whether it's been looking at what the original drafters intended versus what principles for treaty interpretation should be applied, or whether it's debate about the term how that term has evolved, and considering issues such as the law on state responsibility, other areas of international law and how that impacts this understanding, and obviously the subsequent practice of states, which is really important. We tried to capture some of that analysis, and since the release of the 2016 ICRC updated commentaries, there's been a real acceleration of interest in Common Article 1 and reflection about the scope and the extent of ensure respect particularly. So what it comes down to really is whether or not commentators believe that in opposition to respect being an internal compliance aspect, whether ensure respect has an external compliance aspect, is that what it is? And whether or not that external compliance aspect can be demonstrated both negatively by not aiding or assisting a violation of IHL, but also whether it can be demonstrated positively through assertive action to prevent or halt a violation. What that would mean is that a state which is the signatory to the Geneva Conventions or additional protocols, but which isn't directly involved in an armed conflict, a third state, how would that third state either refrain from particular acts which support or encourage a violation or potential violation by a party to the conflict, or indeed activity which might interfere with the lawful operation of IHL, but also how or whether that third state is obligated to take particular positive steps against a party to a conflict in order to bring that party back to a position of respecting the law. We concluded that there was such a requirement, but having drawn that conclusion, what we then wanted to explore was what that external compliance would look like. The aim was to identify practical steps that states themselves could adopt to demonstrate they were engaging with the concept of ensuring respect for IHL. To successfully discharge this obligation to ensure respect doesn't actually mean that a state is responsible for the outcome of the conduct of the parties to the conflict. They are, however, required to act with due diligence regarding the situation and choose an appropriate course of action to attempt to prevent that violation. And these were the practical steps that we wanted to try and identify. And obviously those steps are dependent on the influence the third state may have over the party to the conflict. And that relationship is dynamic. It's going to depend on military, economic, political or social ties between the identified parties. And I guess one of the things that we were trying to identify for readers or help them understand is what level of critical analysis might need to be exercised to assess whether a third state has acted reasonably. So to try and introduce that. What we found from the contributions were three broad themes, as we've referred to them, which form a kind of spectrum of practical measures that states can adopt that may fulfill the requirement to ensure respect for IHL. Now, at one end, there are individual state actions, mostly domestic in character, which are also designed to respect IHL training, dissemination, enacting and implementing your domestic law. So it's keeping one's own house in order. The next stage, in a sense, so the second theme we identified was collective state action conducted at a regional and international level, so multilaterally, which builds on this individual work and creates a strong, respectful framework for IHL globally. These categories of action might actually be both globally removed and, geographically removed and also distant in time from an actual conflict. And they're continuous actions because they're there to build a conducive environment for the respect of IHL when it is most needed. At the other end of that spectrum of practical measures are those actions which can be used by third states in a much more direct or may have, where a state has a more direct or tangible influence over a party involved in an armed conflict, and to be used to encourage compliance with IHL. And that influence may be exercised through persuasive, diplomatic, confidential channels, but equally through much more publicly assertive and coercive measures, such as the application of sanctions. So a real range of opportunities there. Obviously, these practical measures overlap, they're mutually reinforcing, they're not siloed actions, and they are complementary. And at any given time, in response to a potential breach, there may be multiple third states undertaking different kinds of actions in respect, in order to try and, draw a party back to a position of respecting the law. Now, what we hoped has been achieved by presenting the ideas that we have across a range of topics, and our authors have looked at all sorts of things, taking a specific focus, for example, on implementing domestic legislation, or focusing on counterterrorism law, or considering the conduct of private actors, foreign fighters, peacekeepers, an examination of detention in armed conflict, to really broad issues like the developments in artificial intelligence and the creation of international criminal tribunals. What we wanted to do was to be part of the process of enabling reflection by states as to how their actions contribute to or detract from the notion of how to respect, or how to ensure respect, I should say, for IHL. We hope that you enjoy those contributions, and we certainly look forward to your questions. But I'll pass the floor back to Carolina so she can invite our next speaker.
Thank you. Thank you, Annabel, for this introduction of the book. And now we will move forward with Catherine, that she will present Chapter 5, Ensuring Respect for IHL, by and in relation to the conduct of private actors. Thank you, Catherine. The floor is yours.
Thank you very much, and I'm very pleased to be here to speak about my chapter in this really excellent collection that covers a lot of thought-provoking topics, as Annabel has mentioned. So my topic focuses on private actors, which I have defined in the book as natural or legal persons who are not acting by or on behalf of a state. So this would usually capture business individuals or entities such as companies that are acting pursuant to commercial or personal interests. Now the chapter does two things, which I'll cover in my remarks today. The first is to look at what we already know about the content and scope of the duty to ensure respect for IHL, and ask how private actors fit into that. And the second is to look at some practical steps that states can and should take in order to comply with their duty to ensure respect for IHL in relation to the conduct of private actors. So turning to the first, how do private actors fit into the duty in Common Article 1? As Annabel said, it's commonly understood that Common Article 1 has an internal and an external dimension. And it's argued in the chapter that private actors fit into both. So the internal dimension concerns the state's duty to ensure respect for IHL in relation to persons over which the state has jurisdiction. So in relation to private actors, that would include private actors operating within the state's territory and subject to its territorial jurisdiction, but it would also include nationals of the state and companies incorporated in the state that are operating outside the state's territory, but which are subject to its extraterritorial jurisdiction on the basis of nationality. So to take just one example, the Dutch businessman Gus Korenhoven, who was prosecuted and convicted for his role in aiding and abetting war crimes in the Liberian Civil War. He was a Dutch national who was operating extraterritorially and was facilitating the violation of IHL through the provision of weapons and material assistance to the Charles Taylor regime in return for preferential treatment for his timber companies. So he was a national of the Netherlands, subject to the Netherlands jurisdiction, and they prosecuted him for his extraterritorial conduct. So that's the internal dimension, private actors in the state's territory and also operating extraterritorially. And then there's the external dimension of the duty to ensure respect for IHL, which Annabel touched on in some detail and which is in many respects a large focus of many of the contributions in the book. So the external aspect of the duty to ensure respect for IHL is about whether the state has a duty to ensure respect in relation to the conduct of persons outside the state's jurisdiction. And this is commonly discussed in terms of the duty towards the conduct of third states or parties to the conflict, but it also has application in relation to private actors. And a good example of this is where there's a parent company incorporated in a state's territory, and it has a foreign subsidiary operating in another country, perhaps in a conflict zone. In relation to the state, that foreign subsidiary is a private actor that is outside the state's jurisdiction, but it still may be a private actor in relation to which the state has some sort of duty in relation to the external compliance dimension to ensure respect for IHL. Now, a concrete example of this, and concrete perhaps is a pun here, but a good example is the situation of Lafarge, which is a French cement company incorporated in France. It has a subsidiary in Syria, incorporated under Syrian law. That Syrian subsidiary was paying bribes to ISIS and other non-state actors during the Syrian conflict in return for security so that its cement operations could continue amidst the civil war. Now, in relation to France, that Syrian subsidiary is a foreign private actor outside France's jurisdiction, but it still is a company that the state has some relationship of influence over by virtue of the parent company being located in French territory and being incorporated in France. So that is a situation in which the external dimension of the duty to ensure respect can capture the conduct of private actors. But as Annabel mentioned, this external aspect of the duty to ensure respect for IHL is, of course, dependent on the relationship between the state and the ultimate perpetrator of the violation of IHL, and whether or not there's a relationship of influence there that can capture the conduct of private actors. So that's the internal and the external dimension of the duty to ensure respect for IHL and how each of those might capture private actors. And additionally, as Annabel mentioned, the duty to ensure respect also has a positive and a negative dimension. So the negative dimension, or the negative duty, is an obligation on states not to assist or encourage the violation of IHL. And that would include the duty not to assist or encourage private actors to violate IHL. So this may be relevant where there are private actors that are directly participating in hostilities, such as private security or military companies, for example, that may be contracted by a state. So that's the negative duty. And the positive duty, as Annabel mentioned, is the duty on states to take positive actions in relation to the conduct of private actors in order to prevent the commission of an IHL violation and ensure respect for IHL. And this is in many respects one of the main focuses of the chapter, because it concerns a situation that arises in many different examples of where the private actor is just one link in a chain in the relationship between the state and the ultimate commission of the IHL violation. And I'll give you a good example of this. In 2012, a cargo ship left Russia en route for Syria to deliver 3 Mi-25 attack helicopters. This was just after the well-documented use of heavy artillery by the Assad regime against civilians in the Syrian civil war. The United States government found out about the cargo and the nature of the voyage, and they contacted the British government. The British government contacted the British insurer, Standard Club, that had insured the vessel for this voyage. They told Standard Club of the cargo and the nature of the voyage, and Standard Club revoked the insurance contract on that voyage, and the ship returned to port without delivering the cargo. So that is an example in which one private actor was one link in the chain between the state, the United States government and the UK government in this case, and the ultimate potential violation of IHL that would have occurred. And by exerting influence over just one private actor in the chain, those states took positive actions to fulfill the positive dimension of the duty to ensure respect for IHL in relation to the conduct of private actors here. So that is a very, very broad brush picture of how private actors fit into both the internal and the external dimension of the duty to ensure respect for IHL, and the positive and the negative aspects of that duty. So that's the first part of the chapter. And the second part, which is the crux of the chapter, is a practical examination of what kind of steps states can and should take to ensure respect for IHL in relation to the conduct of private actors. And the crux of the idea here is that states need to know of the connections between existing and potential conflicts and parties to those conflicts and private actors, so that states can understand which private actors they have jurisdiction over, which private actors they may have influence over, even if they're outside their jurisdiction, and therefore have the information to enable them to know what steps they can take in relation to these private actors in order to potentially prevent violations of IHL and ultimately ensure respect for IHL. So the chapter proposes 2 broad kind of mapping exercises to help the states get the information about this network of connections. The first is an activity-based mapping exercise, which identifies what activities are likely to have a serious risk of facilitating or causing a violation of IHL. And then it proposes general measures, general legislative and administrative measures to address those activity-based risks. And the second mapping exercise is an actor-specific mapping exercise. So it is one that maps the existing or potential conflicts or situations of occupation, the parties to those conflicts or situations of occupation, and private actors with connections to those situations, so that states can identify the particular actors that may be engaging in activities that are likely to cause violations of IHL, and identify when and how they can take specific action in relation to those risks. So the activity and the actor-specific mapping exercises are designed to sit together, but they also have 2 distinct levels, which is important when dealing with private actors. And that is because measures that are designed to, for example, ensure respect for IHL that are directed towards other states or parties to the conflict are different to measures that are directed towards private actors, because private actors often have concrete rights that are protected by domestic, regional, and international regimes. purely reactive measures directed towards private actors in response to a perceived risk of an IHL violation could potentially breach the private rights held by these private actors under these various domestic, regional and international regimes. For that reason, it's important to have in place general legislative and administrative frameworks that identify and address specific activity-based risks, which can then be applied in certain concrete cases in relation to private individuals and private actors. And it's this two-step or two-level system that is able to allow the state to implement sophisticated tools to capture the conduct of private actors and to implement them in a way that both respects the rights of the private actors and regulates risks of IHL violations. Now, the chapter sets out those specific mapping exercises in a little bit more detail and explains how, in a number of respects, some of the activities states already have to do under various treaty regimes might already overlap to a certain extent. For example, various treaty regimes about outlawing the illicit trade in weapons or regulating the lawful trade in weapons sets up regimes that might do the same kind of activity risk-based analysis that this mapping exercise recommends. So there is potential overlap in respect of some of the activities, but certainly not in respect of all of them. And the chapter makes a number of recommendations about general measures that might be implemented on a whole kind of commercial private actor spectrum. Now, in addition to these mapping exercises, the chapter addresses a number of practical considerations which have to be taken into account. The first is access to information. How do states get the information they need about what private actors are operating where and with whom? And the chapter makes a number of recommendations about mandatory or voluntary reporting requirements and draws on a number of existing regimes in other jurisdictions or jurisdictions across the world that do have mandatory reporting requirements for certain human rights and environmental purposes, which could be translated into the IHL context. So there's access to information concerns. There's also capacity concerns. Not all states will have the same capacity in terms of mapping and monitoring on an ongoing basis existing conflicts and private actors, of which there may be very many. So there are capacity concerns to consider as well. And there are also jurisdictional overreach concerns about the extent to which states can legally regulate the commercial activity of foreign private actors. And there are a number of doctrines that are used in various jurisdictions to deal with this issue, but it is a practical concern that states would need to take into account when they are formulating specific responses to particular risks associated with foreign private actors. So that's the chapter in a nutshell and how it tries to deal with the duty to ensure respect in relation to private actors. And I'll just finish by saying I think that it's very important that states understand that the domestic regulation of private actors and their conflict-connected conduct is very important because private actors, individuals, and companies are bound by very few direct obligations under international law. Individuals, including business officials, are bound only by the criminalised provisions of IHL, i.e. the provisions that would constitute the commission of international crimes. Those are very narrow compared to the scope of commercial activity that private individuals may engage in. Equally, business entities, corporations, companies are not directly bound by any of IHL. And so it really is the task of domestic regulation to regulate otherwise lawful commercial conduct that might contribute to the violation of IHL, to do the hard legwork of controlling the impact that private actors may have on the commission of IHL violations. And some of the practical measures that the chapter outlines are some of the ways that states may think about how to implement their duty to ensure respect in relation to private actors in that way. Thanks very much.
Thank you, Catherine. And now we will move forward with Chapter 8 that will be presented by Eve Massingham, and it's on weapons and the obligation to ensure respect for IHL.
Thank you very much, Carolina, and thank you to Catherine and Annabel for those earlier remarks. As Annabel mentioned, the original catalyst for what has led to this book was some work that I was doing around weapons law and the obligation to ensure respect for international humanitarian law. And so that is the basis of Chapter 8, and the plan is to talk you through that a little bit. As Annabel mentioned, there were some recurring themes that came up throughout the chapters that we identified in this book. And certainly one of those is the idea, as Annabel put it, of getting your own house in order. And you'll see as I go through the discussion on weapons law that is an incredibly important component of it. If you take the obligation to respect international humanitarian law from a weapons law perspective, there are actually a large number of indicators in the conventions and the protocols themselves that tell you as a state exactly what you need to do. And so it's those provisions and the ensure respect extension of them that are particularly important. There is also, of course, in the weapons law space, a huge range of legal frameworks in addition to the Geneva Conventions and their additional protocols, very specific weapons law treaties. And so looking at them and how states approach them and how states can support other states to meet their obligations under those treaties was also an important part. There's also a component of weapons law regulation which is essentially both internally and externally facing in its very nature, which is the idea of import and export controls. And so the way in which a state specifically regulates its processes domestically to allow certain equipment and materials that may be component parts or may contribute to weaponry in some ways is a really important component, and allows a state to both obviously respect but also to ensure respect. And finally, the idea of criminalisation of violations of international humanitarian law that involve the use of weapons. So I'll just speak to those different elements in a little bit more detail. I'll just share a slide with you that I have prepared, which just allows us to, hopefully you can see that now. A thumbs up from someone, if it's working. Excellent. Thank you, Catherine. These are essentially the areas that I identified when I looked at weapons and how you might respect and ensure respect for international humanitarian law through a weapon law lens. These are the issues that I came up with. So the first one is weapons reviews. So as you might be aware, Additional Protocol 1 to the Geneva Conventions in Article 36 requires that states party to that protocol in the development or acquisition of a new means or methods of warfare, which of course would include a weapon. They must look at that means or methods of warfare and consider whether it can be used in compliance with the laws of armed conflict. And so obviously states party to the additional protocol have a specific legal obligation to engage in this weapons review process. This is a process which it's admitted in international law is publicly not, at least publicly not acknowledged by a lot of states that they do it. And the International Committee of the Red Cross has done some investigations and some detailed some details of some states' processes in relation to weapons reviews, but it is certainly a provision that is not done perhaps in the robust way in many states that it could be. But doing these reviews is important for respect. If you don't know whether your weapon can inherently comply with the rules of distinction, proportionality in a time of armed conflict, then you haven't respected international humanitarian law processes. But also, as I articulate in the chapter, there are some significant ensure respect components of this idea of weapons reviews. And the biggest one, and this links to comments that Catherine just made, but also comments from a number of the chapters of the book, is the information sharing component. There is no legal obligation to share your report, to make your findings public, but the sharing of information related to weapons and their ability to comply with international humanitarian law would, of course, play a role in supporting other states to respect the laws of armed conflict. So that was the first component, was to look at weapons reviews. As I flagged, the second component was to look more broadly at a variety of different treaty law obligations. And so in the chapter, I look specifically at the examples that are presented on the slide there. Obviously, there was not scope to discuss every type of weapons treaty, but I have pulled examples throughout the chapter from these four in terms of specific provisions of the treaties, or the idea behind the treaties to demonstrate situations of respect and ensure respect. So one of the examples that I give is in relation to the Cluster Munitions Convention, and specifically Australia's approach to the Cluster Munitions Convention, which the evidence suggests was very much based on trying to ensure that military partners that Australia wished to work with were not going to be hampered by Australia's commitments to the Cluster Munitions Convention. So Australia is a party to the Cluster Munitions Convention, but has ensured that the interoperability provisions in the convention do not prohibit or prevent some of their partnered operations taking place. And so one of the arguments that I make is that had Australia looked at this through a common Article 1 lens, it would have been difficult to maintain a position that Australia needed to support these interoperability provisions. Australia, in respecting and ensuring respect for international humanitarian law, would have needed to find a different way in order to meet their obligations and have other states meet their obligations as well. The ATT, or the Arms Trade Treaty, is also an interesting one, and indeed it's a treaty that is mentioned by a number of authors throughout the book because it crosses a range of different areas, not just weapons. There are linkages in the Arms Trade Treaty negotiations and discussions to a range of issues. But certainly the obligation under the treaty not to transfer weapons where there is a serious risk of an international humanitarian law violation enacts the ensure respect obligation under international humanitarian law. So that's just a couple of examples. Moving then to the third part, the training and doctrine components. So obviously you have to have your own house in order to respect international humanitarian law. The Geneva Conventions specifically require states to disseminate information about the conventions. They require that their military personnel know what the conventions say, and in Additional Protocol 1 that their legal officers are supporting the commanders to respect international humanitarian law. But obviously an external dimension of this would be the role that states can play in assisting other states in the development of training and doctrine that respects the laws of armed conflict. I spoke in introducing the topic a little bit about the import and export controls, and obviously having very stringent import and export controls that ensure that materials that would contribute to weaponry that is going to inherently violate the laws of armed conflict would be prohibited from being imported or exported from your jurisdiction would be really important. And then the final component is the idea of criminalisation of violations. So obviously, depending on the domestic legal system of a particular country, depends on how they incorporate the international law protections into domestic law. But a number of countries, common law countries in particular, need to actually have domestic legislation which incorporates those international obligations for those obligations to be able to be a part of domestic law and charged under domestic law. And so the implementation in domestic legal frameworks of obligations under the Geneva Conventions, of course, to investigate and prosecute grave breaches, but also more broadly for those states party to the International Criminal Court, the incorporation of the list of war crimes and other serious violations in the International Criminal Court statute, for example, need to be domesticated and then, where appropriate, followed up. The chapter is more general, but definitely draws on the work that I did in my PhD, which was very specifically to look at this in the Australian context. So I'm just going to put up a little addition to the slide so you can see essentially what the conclusions in the PhD were. I used the asterisk there to say very much, you know, this is a tick and a cross and a question mark sort of approximation of what was discussed. But essentially the findings in relation to Australia's approach to respecting and ensuring respect for international humanitarian law. This is essentially the report card that I gave. Australia does have a very robust Article 36 weapons review process, and it's something that is done, and it's certainly not perfect. There would be faults in the system, but Australia is one of the countries that do this. In terms of specific treaty law obligations, I gave a fairly sort of mixed report card for that. As I mentioned earlier, there were some specific components of the Cluster Munitions Convention where I don't think Australia did consider its common Article 1 obligations at all. And Australia's position on nuclear weapons, in my view, is very much at odds with its obligation to respect and ensure respect for international humanitarian law. But on the Landmines Convention and the Arms Trade Treaty, Australia was quite a leader in some of those negotiations and has implemented those obligations. In relation to training and doctrine, this is quite comprehensively done in the Australian Defence Forces. In relation to import and export controls, I think there's very much a question mark there. There are some fairly comprehensive import and export controls, but certainly there are situations where it would need to be looked at much more closely. Some of the exchanges that of military exchanges that the Australian government is engaged in, and some of the sales of weapons, and certainly newspaper articles to that effect were raised by a couple of authors in the chapter, particularly around sort of the Arms Trade Treaty in practice rather than the treaty obligations in corporations itself. Australia has criminalised war crimes and has incorporated into its Commonwealth Criminal Code war crimes, and that's fairly comprehensive, but as many of you would be aware, has a fairly poor history in relation to prosecution of violations, has had some failed attempts to have some prosecutions in the past, but hasn't had any successful prosecutions. As some of you may well be aware, late last week, an inquiry report was handed down alleging some absolutely horrendous violations of the laws of war by Australian Special Forces in Afghanistan in the period sort of 2007 to 2013. So I've put the question mark there because I think it absolutely remains to be seen. It may be some years before one can have a more clear answer in relation to that. There certainly seems to be an indication from the government that they are taking these allegations incredibly seriously and that there will be war crimes prosecutions forthcoming in the Australian context. But it's probably a little bit early to see how that exactly plays out. So I think there are a number of things that states can do to better ensure respect for international humanitarian law in relation to weapons law. And in the conclusions to the chapter, I mention a few of those around things like sharing publicly or at least with other states of relevance, some information obtained through Article 36 reviews, supporting other states, of course, to meet their treaty obligations. Very difficult to do that if you are not doing it yourself as well, though. So having the moral authority to do so is really important. Having really stringent import and export controls and supporting other states in their training. But I think ultimately what it comes down to and what I propose in the conclusion to the chapter is to actually consider Common Article 1 when thinking about these obligations. Common Article 1 is the first provision of the Geneva Conventions, and as some commentators have identified, for such a significant place, I suppose, in international humanitarian law, it's actually attracted fairly little attention over the years, and certainly in the drafting of it, it wasn't really discussed in a great deal of detail. And I think that there is more that states can get out of Common Article 1. There is more that the protection of civilians ultimately can get from Common Article 1. And so I propose that in approaching any of the issues that are before you on the slide, a state looks at it through a Common Article 1 lens, and that would ensure better respect for international humanitarian law. I'll stop sharing my screen and hand back to Carolina for Nathalie's presentation. Thank you.
Thank you, Eve. And now we will move forward with the chapter 13 by Nathalie Weizmann, which is on ensuring respect for IHL as it relates to humanitarian activities.
Thank you very much. It's a pleasure to see you all, and thank you for those who are already in tomorrow for bearing with this. I much appreciate your making the time to fit me in. All right, so in this chapter, I've endeavored to lay out a range of ways in which third states have taken steps to ensure respect for IHL as it relates to humanitarian activities. And what's interesting about IHL in this on this theme is that IHL actually also lays out rules for third states to comply with in order to allow humanitarian activities to be carried out. But before I get into what those IHL obligations are for third states and more generally what states should be doing to ensure respect for IHL, let me just take you through very succinctly the basically three key elements of IHL that relate to allowing humanitarian activities to be carried out in situations of armed conflict. And so the first relates to the need to obtain the consent of the state where humanitarian activities are being carried out by an impartial humanitarian actor. And that consent must not be withheld arbitrarily. There's been plenty of debate over what that means, but that's not the aim right here at this very moment. But the first step is consent, and you'll see how that has come up in states' efforts to ensure respect for IHL. The second step is once that consent is obtained, all parties to an armed conflict, state, non-state, territorial state, or other, must allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, and allow the freedom of movement required to do so. And this requires lifting impediments, but also more proactive steps to expedite passage. And then, of course, there's an obligation to respect and protect humanitarian relief personnel and assets, which has been understood to entail prohibiting harassment, intimidation, arbitrary detention of personnel, but also prohibiting the destruction, misappropriation, and looting of assets. So those are just, that was just to recap the three key, again, there's a lot more to it, but the three key areas of IHL that relate to humanitarian activities, because that's what recurs in efforts to ensure respect in order to allow humanitarian activities to be carried out. But before I get to that, let me just take you through some interesting aspects of IHL that require third states to also consent to and allow and facilitate humanitarian relief. And these are found in provisions relating to international armed conflict. Unfortunately, those relating to non-international armed conflict are silent, but we still have ensure respect for those situations, of course. But in international armed conflict, there is often reference to the contracting parties, the high contracting parties, or the parties concerned, which are understood to refer not just to the parties to the armed conflict, but to all states. And in a number of provisions, IHL requires that, for example, all high contracting parties consent to relief activities, relief actions, or all states allow and facilitate rapid and unimpeded passage of humanitarian relief once that consent is obtained from them. And this often relates, of course, to neighboring countries in which the humanitarian relief operations are initiated or through which they have to transit. But again, it's interesting to note that perhaps unlike in other areas of IHL, there is some IHL law. There are IHL provisions that relate to the role of third states. There's also a requirement that all high contracting parties, this is in Additional Protocol 1, encourage and facilitate the effective international coordination of relief actions. And so what I haven't yet pointed out is that there is some distinction between rules relating to relief operations, relief activities, which are a narrow subset of humanitarian activities. And then there are some additional provisions that relate to relief activities, to humanitarian activities as a whole, which are broader than relief. Relief aims to meet essential needs. And of course, humanitarian activities can go well beyond meeting essential needs such as food, water, shelter. And so, for example, on humanitarian activities more broadly, Article 81 of Additional Protocol 1, again, still in international armed conflict, first makes a distinction between Red Cross and Red Crescent organizations, which have a privileged place in this provision. And so it makes a distinction between them and other humanitarian organizations. But to give you an example, Article 81 requires all high contracting parties to facilitate in every possible way the assistance that Red Cross and Red Crescent organizations offer for victims of armed conflict in another country. But then with more nuanced wording, it's not as absolute. The same provision requires all high contracting parties to make similar facilities available to other humanitarian organizations as far as possible in order to allow assistance to or humanitarian activities more broadly to be carried out. And this can entail facilities for travel, for transmission of correspondence, for the transfer of funds, for the rapid movement of supplies, as well as exemptions from customs duties. So that was just to take you through a few examples of how, again, third states also have IHL obligations relating to humanitarian activities. But of course, the core of the chapter aimed to look at what third states more generally have done and should do in order to ensure respect of IHL as it relates to humanitarian activities. And what's been quite difficult to determine is whether these forms of influence that I'll describe have been carried out as a matter of law or as a matter of good practice and policy. It's rarely stated whether given country speaking out or trying to use its influence to negotiate humanitarian access is doing so on the basis of Common Article 1 or something else. But a number of third states have, through diplomacy, advocacy, dissemination activities, taken steps to use their leverage, their influence to facilitate humanitarian activities. It's also quite difficult to find examples of this, but in 2016, the UN hosted a World Humanitarian Summit, and it was quite a useful opportunity to actually have states come and highlight some of the sort of actions that they were carrying out in order to ensure respect for IHL quite broadly, but in particular as it relates to humanitarian activities, because they were encouraged to make commitments and then over the years to follow up on how those commitments were being carried out. And so this was a good opportunity and a good place to actually find examples. And so one example that Denmark gave was that in 2017, it led a group of other diplomats to help negotiate humanitarian access to northern Rakhine in Myanmar for the ICRC and the Myanmar Red Cross. Spain reported that it uses its leverage and influence at bilateral but also multilateral levels to foster impartial humanitarian relief in contexts such as Yemen, Nigeria, and Mali, for example. Of course, I'm sure we've all heard about, or we've all heard a number of statements from a number of countries over the years speaking out against impediments and to encourage full, safe, unhindered humanitarian access. So Canada, for example, has reported as part of this World Humanitarian Summit follow-up that it has spoken out on constraints in situations such as Syria, of course, Myanmar, Ukraine, Mali, and Iraq. More recently, so this was in the autumn of last year, France and Germany launched a call for action on IHL with a focus on humanitarian action, but of course many of the steps that they lay out in order to ensure respect for IHL as it relates to humanitarian action are applicable well beyond. They call for dissemination and training. They call for the adoption of appropriate domestic legislation, and at least 40 states have signed on to that. So those are just some examples of how third states have, on an individual basis or sort of a small cluster of countries, have taken steps. But there's quite a bit of opportunity and potential for third states to take quite influential action when they're on the Security Council. So at any given time, there are 15 states on the Security Council at the UN, and the Security Council has taken over the years a number of measures in the forms of resolutions or presidential statements to pursue, to ensure that humanitarian activities are carried out in compliance in line with IHL. And so, as you know, the UN Security Council decisions are legally binding. Not every act that the Security Council takes is a decision that would be legally binding, but it has adopted resolutions and other sort of instruments in country-specific situations, but also on thematic issues that I will take you through. One of probably the most, the strongest manifestation of the Security Council, the Security Council's influence in this area is in a resolution on Syria that it adopted in 2014. When, to come back to the IHL outline I gave you much earlier, the government was not consenting to humanitarian operations of the UN and its implementing partners. The situation was naturally dire, and the Security Council, in an unprecedented move, adopted a resolution in which it decided, so making that decision legally binding, it decided to authorize the UN to carry out humanitarian assistance operations with its humanitarian partners across conflict lines, but also across certain border crossings in order to meet needs that were otherwise unmet. And this was the first time that the Security Council in this area had made such a decision that essentially overrode the Syrian sovereignty and Syria's refusal of humanitarian operations. This resolution is still in effect, though we've lost 3 of the 4 border crossings. There is one that remains, and it is up for possible renewal in the summer. So that's sort of the strongest we've seen. And interestingly, it has equated the arbitrary withholding of consent with a threat to international peace and security. And this isn't the only instance in which it has given the failure to grant access that kind of that level of importance. So short of overriding the requirement of state consent, the Security Council in the situation in Yemen, in relation to Yemen in 2015, also recalled that arbitrary denial of humanitarian access and depriving civilians of objects indispensable to their survival could constitute a violation of IHL, and urged all parties to facilitate the delivery of humanitarian assistance. The Security Council, in other instances relating to Syria, Yemen, the Lake Chad Basin, and others, has referred to specific arrangements to enable humanitarian assistance to be carried out, such as corridors, pauses, days of tranquility, ceasefires, and truces. So there's a lot to be found, and this was just a very quick overview in country-specific resolutions and, again, other types of instruments that the Security Council adopts. But of course, there are also what we call thematic resolutions, which are, as the adjective describes, on specific themes. And I can take you to maybe through two or three such themes. The first would be its relatively recent resolution on conflict and hunger, adopted in 2018. It's a remarkably elaborate resolution when it comes to laying out all the ways in which IHL acts as a line of defense for hunger or against hunger in armed conflict. And what's also remarkable about it is that in addition to recalling and calling on parties, I should say, to armed conflict to comply with their obligations of IHL as they relate to humanitarian access, it also calls on third states. So you have third states calling on other third states, including neighboring countries, for example, to cooperate fully with the UN and other agencies in providing access. And importantly, also urges those with influence over parties to an armed conflict to remind them of their obligations to comply with IHL. And so without referring to Common Article 1 specifically, this is very much a reflection of the Common Article 1 obligation to ensure respect. Now, what's also quite remarkable about this resolution is that it asks the Secretary General to bring to its attention situations in which there is a growing risk of conflict-induced food insecurity, so that the Council can then take more action in order to try and put an end to it, and prevent violations, and ultimately ensure that famine doesn't result or acute food insecurity doesn't result. And so it creates a mechanism of feedback so that it can continue to take more action. And that's, I think, one of the most elaborate, probably the most elaborate resolution that I've seen so far that relates to what third states are doing and should do in relation to humanitarian activities. In relation to children in armed conflict, there's another interesting mechanism that the Security Council has triggered. In 2005, it asked the Secretary General to set up what is called a monitoring and reporting mechanism on grave violations against children in armed conflict. It's called the MRM, and it gathers information on a range of types of behavior of combatants that ultimately harm children, ranging from attacks on hospitals and schools to the denial of humanitarian access. It refers to grave violations, but it doesn't necessarily, those grave violations, there are 6 of them, don't necessarily equate with IHL violations. Sometimes they do, sometimes they don't. And so one of those grave violations is the denial of humanitarian access. And so in addition to monitoring and reporting on the denial of humanitarian access for children, now in something like 20 situations of armed conflict, there is also a working group composed of all Security Council members that then takes this information and makes recommendations for follow-up with certain countries that are problematic. And so, to give you a couple of examples, this working group has taken this information and then recommended, for example, that the Security Council transmit a letter to the government of Syria urging it to allow and facilitate safe, timely, unimpeded humanitarian access. It can also issue public statements, again, to call on parties to respect IHL in this area. And for example, in relation to the situation in Myanmar last year, it, if I recall correctly, I'm just looking at my notes here, I think it issued a statement calling on the government of Myanmar to allow, to give to the UN partners and NGOs immediate, safe, and unhindered humanitarian access to 3 areas in Yemen. Perhaps one last area that is also quite decisive at the Security Council level is its ability to impose sanctions. And here too, this is decisive. These are legally binding, and the Security Council, in 6 contexts in Somalia, Yemen, the DRC, Mali, South Sudan, and Central African Republic, has the ability to impose sanctions where individuals and entities are engaged in or support acts that obstruct the delivery or distribution of access to humanitarian assistance. So this is one other way in which the Security Council can take steps to make it more difficult to obstruct and also end obstructions of humanitarian activities. Now, this sort of trigger has been used. It is not as commonly used as other triggers for sanctions, as you might imagine, and often other very sort of prominent reasons for triggering sanctions will come up first. But there are instances in which the obstruction of humanitarian assistance has been the basis for designating an individual or a group under sanctions. And one is in Mali. An individual in Mali, a member of a coalition of armed groups in July 2019, was designated because he was manipulating humanitarian aid to fulfill his personal interests and the political interests of the coalition of armed groups by exercising terror, threatening NGOs, and controlling their operations, all of which resulted in the obstruction and hindrance of aid affecting beneficiaries in need in a specific region of Mali. So this is another example in which the Security Council tries to take active steps to put an end to the obstruction and also make it more difficult to obstruct humanitarian assistance. Now, what's also interesting is that at times sanctions of different kinds can inadvertently impede humanitarian activities. And so here too, the Security Council has noted this and taken steps to make sure that the sanctions that it imposes do not actually impede humanitarian activities. And so, for example, in relation to arms embargoes, it has understood that in certain instances, humanitarians might need certain material that is caught under an arms embargo, and they might need it for their protective and strictly humanitarian use. And so exemptions have been carved out for them to be able to still import, bring in the materials that they need for their own use. And similarly, there are flight bans that have been imposed by the Security Council, but you might see how flight bans could inadvertently catch humanitarian flights. And so in a couple of contexts in Afghanistan, in Libya, space has been carved out so that, of course, humanitarian flights can nevertheless take place despite the flight ban imposed by the Council. And of course, where there are economic sanctions, this is made clear in the sanctions regime relating to Somalia. There can be economic sanctions that can inadvertently catch transactions that humanitarians carry out that might incidentally give funds to sanctioned groups as part of humanitarian activities. And so here too, in the sanctions regime on Somalia, there is a very explicit exemption saying that the economic sanctions do not apply to the payment of funds or other financial assets necessary to ensure the timely delivery of urgently needed humanitarian assistance. Those are just some examples of, again, how the Security Council has taken steps to enable humanitarian activities. So I've attempted to give you a range to illustrate a range of ways in which third states take steps, both on a bilateral and multilateral level. And as I conclude in the chapter, I think this leaves us with a robust catalog of options that all states can take to ensure respect for IHL as it relates to humanitarian activities. Thank you.
Thank you, Nathalie. Let's see. So now we're moving, as we are back with electricity and everything is back to normal. We are moving to the Q&A part. We don't have much time, taking into account that it is tomorrow for at least half of our speakers, and sleep deprivation has been an issue in other parts. And so we have one question in the to Eve in the chat, if you would like to address it. But I do have one question which I think might be relevant to all of the panel, and later on we'll see with regard to time if we have the option to take more questions. And my question is about identifying positive or good practice of IHL as part of ensuring respect to IHL, because we do know that a lot of the times we hear about violations and we advance through violations, or we tend to assume that most states obey to most international law most of the time. But with regard to IHL, we don't have much of that discussion. I know that there is a project going on with the ICRC and a few legal clinics, including the IDC in Herzliya and Israel, which is led by one of our friends, Yael Weizmann, dealing with that. But I want to hear your perspective of how to identify and how to make sure that positive implementation of IHL is being both emphasized and identified. And identify, I think, is the biggest issue, because we don't hear about not sending weapons usually to a set of violation, or not attacking civilians, which is the basics of the basics. We just don't hear about it because no one attacked most of the times. So that's my general question. And if let's start with
happy to. So yes, absolutely agree with the view that just because another state, or indeed a private entity, a weapons manufacturer, or indeed anybody has shared information from a weapons review with you would not absolve your state of its own obligation. It's clearly an obligation on states, and they would not be able to just blanket rely on other information provided by others. So I absolutely agree with that proposition. The point about sharing the information about what makes a good weapons review process, or what information comes out of weapons reviews, is a contribution, but it's certainly not the end of the story. And I think that even in the future, if there is more exchange, there absolutely is no change to that legal obligation. So I completely agree with that question. Perhaps then, just in the interest of time, to give a couple of reflections on Ida's question, and you would be conscious from the introductions that I obviously come at this with a very Red Crescent movement background as well. So of course the work that the organisation has been doing in recent years to identify that there is good practice happening very much does come from the lived experiences of working in these situations. And I guess my personal experience and reflection has been that international humanitarian law in lots of situations is not going to prevent the large violation. It's not going to prevent the dropping of a bomb on a hospital, as an example, but it is going to give humanitarian workers access to an area where civilians need assistance. It is going to give the Red Crescent movement, for example, access to a detention facility where they can provide some incredibly important assistance to individuals and to groups at those facilities. So, I absolutely agree. I think there is more that can be done around promoting positive practice with the law of armed conflict. Yes, it's not a very good media story that the Geneva Conventions were complied with today. The violation is always going to sort of attract the interest. But I absolutely agree. I think there is more that we can do to highlight situations where actually the laws of war do assist. And indeed, there is quite an old study now that says that people in conflict zones have a much higher respect for the laws of armed conflict because they've actually seen them in practice and they've seen them impact on day-to-day lives. And in a country like Australia, where we're fortunately not affected by armed conflict, the appreciation for the Geneva Conventions is very low in our society. So there's definitely some lessons from that. But I'll give the floor to some other panelists.
Annabel?
Yes, look, I know that we often say if you have a new group of students that you're talking to and you're discussing international law, there might be politics students who are coming in, there's always great skepticism about what, you know, international law doesn't work, what does it do? And of course you have to start with the you know, the comment that international law isn't a panacea for all the world's ills. It's just one of the tools that we have available, and you need to be very realistic about what it can do and what it can't do. But the socialization of laws is what it's about, so that you do get to the point where, and as Eve said, you know, the violation is the thing that's going to get noted and counted and identified. It's not the what doesn't happen. In the same way that we report on the news when road traffic accidents occur. We don't actually then balance that with, but 4 million people arrived safely at work today by travelling in their cars. We don't always identify that, and it's much easier in reporting to identify those the violations, if you like. When we did do a recent presentation about the book, and Helen Durham from the ICRC spoke kindly, having written the foreword to this collected work, and she did say that it is very difficult to measure when something doesn't happen. So if what you've done is prevent a violation of IHL, it's really difficult to measure that you can't see when the bomb hasn't been dropped, when a decision was made not to target something, when a civilian was protected, because the situation of the civilian should always be that protected state. And you don't identify when it was vulnerable, and then the targeting was taken away and a violation of IHL was prevented. So yeah, I think it's really difficult to measure good practice for states, but I think in all of the chapters in this book, so Catherine, when you talk about the mechanisms that can be put in to identify activities or actors who may be at risk, and then identify regulations that can be put into place for private actors, then those are steps that can be taken. Nathalie, as well, when you identify what has happened in the UN and, you know, shine a light on, this was an instance where the issue of consent was discussed and a decision was made that even though consent is required, we need to move past that because there's a greater need, then we need to shine that light on those things. And it's difficult. I think it is difficult. I don't know what other people think.
Catherine?
Yes, thanks, Annabel. Annabel touched on some things that I thought were interesting in response to the question, which are that when there are general frameworks that are put in place for the purpose of aiming at the prevention of IHL violations, those are positive general measures that might be able to be referred to and touted as good practice, even if it's difficult to measure the concrete impact that they are having. But in certain respects, it will be able to measure, those types of frameworks will be able to produce some things that can be measured. It just might not be on the level of specific violations of IHL being avoided. It might be on the level of measuring impacts of how many private actors or how many companies, for example, were caught by regulations that were targeted at prohibiting certain types of activity. And so although these structures aren't already in place with a specific Common Article 1 lens, I think we can see similar mechanisms in place in relation to, for example, the business and human rights movement or the measures to combat modern slavery. Those are types of general frameworks that aim at mandatory reporting, that aim at voluntary self-reporting by companies, but also reporting by partners of companies, and external reporting by NGOs in terms of making business practices more transparent and more compliant with human rights standards. And those types of frameworks are included in annual reports by companies, they're included in parliamentary reports, there's public attention when businesses are caught out for doing things that they shouldn't do. So those are general frameworks that can aim at positive outcomes for IHL, that can produce some measurable impacts, even if it's just on a smaller scale than a broader X number of IHL violations were prevented, so to speak.
Nathalie?
Sure, just very briefly, I realize it's later than when you said you would end this event. So in relation to humanitarian activities, I can say that in my day-to-day job, I do see good practice, and that that witnessing of good practice is then used, from one context to the next to try and encourage good practice across other contexts. We also certainly see patterns of bad practice and come up with arguments against them, and then use those arguments across contexts. So that is definitely a daily practice. But I think what is lacking, or certainly is we could see more of, especially in relation to this theme, is sort of making that known. I first of all, don't have much time to make that known. Some of it can't be made known, but also I think that it's an area that is perhaps there's less attention to humanitarian activities than there is to the conduct of hostilities, for example. Which is why I'm very grateful that you had an entire chapter dedicated to this theme in your book. Whenever I have the opportunity to speak to students, I realize, how few of them actually learn this, and in their IHL class. I never did, and I had the best professor, on the planet. So I think it might be more a matter of finding the outlets and the opportunities to make that good practice known. I also think that in relation to this theme of humanitarian activities and assistance, there is a rule that requires proactivity, right? It requires allowing and facilitating, not just refraining from doing bad things. And so it's also perhaps easier to identify good practice in allowing and facilitating access. But I also should say that in relation to the conduct of hostilities, at least where I sit, there is quite a bit of open discussion. Many NGOs and also parts of the UN do regularly organize meetings with states to unpack good practice as it relates to the conduct of hostilities, as it relates to their support for partners in coalitions. In fact, in a couple of weeks, a couple of NGOs and the UN is going to be supporting this, are holding exactly that kind of meeting to explore good practice in sort of security assistance and military coalitions. So this does happen. It probably just doesn't get enough attention, and there probably aren't enough outlets, and maybe there just aren't enough practitioners to make more noise about it. But yeah, those are just some thoughts. Thank you.
Okay, thank you very much. I think that would conclude our session. As again, I think some part of the world should be going to sleep now, and other parts should get starting to work. I want to thank you all for coming. I want to thank the speakers, Annabel, Eve, Catherine, and Nathalie, for joining us for this book launch. I want to thank a lot to Carolina, who helped us throughout the process and actually moderate most of today's session. And also the guests who came throughout the timing, wherever you are. Actually, it wasn't an easy hour everywhere in the world, which I love that part of this event, but made it very, very unique and special. The edited version of this event will be uploaded to our YouTube channel within a few days. And our next event is scheduled for the end of January. We will provide information about it, so subscribe to our either mailing list or our social media. And with that, I think we're going to conclude. I want to thank again the speakers, and that's it. Thank you very, very much for coming.
Thank you.
Thank you very much for having us.